What's happening, everybody? I am the other Steve, and I am with the trial chief, Stephen P. New. Before I get to Stephen P. New, I would like to thank all of our new subscribers. We're semi blowing up. If you are one of them, thank you for giving us your time. Before going forward, I want to let you know that yes, the House of Kayfabe is where you're going to get the Stephen P. New wrestling law videos, but we're also a collective of 5 or 6 buddies that like to get together and talk about wrestling. We hope you enjoy all those videos as well. And that leaves me to one of my good friends that I haven't seen since WrestleMania, Stephen P. New. What's happening?
Hey, how are you doing, Barker?
Well, I'm glad to be back on the wrestling law videos. I took a sabbatical because I just did not want to get down in the muck of the subject. But as they say in journalism, some stories has legs, and this story certainly has legs. Now, first, I want to put you over before we start talking about this case. And specifically how John Laurinaitis has reared his head again. You predicted that when Vince McMahon released his response to the Janelle Grant suit, you predicted that John Laurinaitis may come back into the fold.
Yes, I think I predicted on the video that Brian Resner and I did that Laurinaitis would join McMahon's motion to compel arbitration.
And that brings us to what we're talking about today. He has filed a motion to compel arbitration. Now, these videos are here to have a mark to tell the rest of us marks about the most mysterious thing in all of American culture, the law. Why does John Laurinaitis have any say on giving another suit some sort of backing or gravitas or weight just because, hey, I would like him to do arbitration?
Well, the way that he sued, Laurinaitis is a co-defendant to World Wrestling Entertainment, Vince McMahon, and he is sued both in his individual capacity and as a capacity of a former head of creative or whatever Johnny Ace's formal title was with WWE. So you got to remember, you got 3 defendants here. You have Vince McMahon individually and as the former CEO and president of the board for WWE, John Laurinaitis individually and in his capacity as head of talent relations, and WWE as a corporation. And so you've got 3 entities here, and Grant's contract, or I guess the deal apparently struck, was with McMahon, but that release, if you recall from the previous video, the release language released WWE, all of WWE's employees, directors, officers, everybody like that. So that sweeping release that Grant signed apparently would have covered Johnny Ace, as well as the arbitration provision in the same release and settlement agreement that she apparently signed.
Now, if you've been following this case, you'll know that initially John Laurinaitis came out and said, hey, I am a victim as well. What did you see in the response from Vince McMahon that led you to believe, oh, wait a minute, John Laurinaitis is going to get on the waffle and come back? Was there anything specifically in that case filing that let you thought John Laurinaitis might not be turning heel on Vince McMahon?
Well, obviously, I think it was the level of detail, and we've talked about this privately, Steve, and I talked about it on the previous video with Brian. That response was not your normal motion to compel arbitration. There was a whole lot of teeth to it, and they came out guns a-blazing. So it seems to me that maybe in McMahon's response, Laurinaitis learned some things. Laurinaitis' lawyers are probably sharing some things with McMahon's lawyers. WWE's lawyers are obviously involved, and they probably said, look, we'd better hang together or surely we will hang separately, as Ben Franklin said. And so Laurinaitis has realized, hey, this girl wasn't the girl that was portrayed in her lawsuit. she's in this open relationship with this lawyer 4 floors down from McMahon and da 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 da. So it will be real interesting to see what Laurinaitis' take is. He can always pivot in this lawsuit. He is not the deep pocket. Johnny Ace is not the target defendant of the three here. The multi-billion-dollar publicly traded corporation and the billionaire, I submit to you, might be the target defendant, Stevie.
Well, for as long as he's worked for the WWE, it's not like he's going to be a pauper as well.
No, he's not going to be a pauper, and this will cost him some cheese. It'll be real interesting to see whether in their contracts, when something like this comes up, if WWE has insurance, normally corporations get defended by insurance companies paying for the lawyers to defend the corporations. And so it will be real interesting to see if a large insurance company who's defending WWE perhaps also is footing the bill for the legal defense for Vince McMahon and John Laurinaitis.
So, Steve New, of course, is teaching everyone the importance of having an LLC when you have a company. Now, of course, this is on
more importantly, having good insurance.
And you can't have that insurance without having the LLC, correct?
Well, you can. Yeah. I mean,
you can have an umbrella without a LLC.
Yeah. Yeah. And it may be more costly if you're a sole proprietorship as opposed to.
And we were talking about an umbrella insurance policy. So if you know anything about Vince McMahon, this is very on brand. So from Ultimate Warrior to Bruno Sammartino, no matter how badly you have stuck the knife in the back of Vince McMahon, he's always ready to do business. And I guess it looks like he's ready to welcome John Laurinaitis back. Now, I'm wondering, will his initial response, which was to say he was a
victim as well as Janal Grant.
Thank you very much, sir. That's why you get paid the big bucks. How much will that come back to haunt this whole case? And does that make his lawyer look weak or incompetent in any way?
I think that the lawyer, particularly if it's one that the insurance company is paying for, I want to start there, Steve, if I can. Mm-hmm. These insurance companies have deals with the largest law firms in America. I mean, DC, New York, LA, Chicago, Miami, London, Paris. So, I mean, these defense firms are just huge, and they can grind you into the ground if they need to. They represent big pharma, big tech, big ag, big food, big you name it. And when those companies get sued, those are the go-to law firms. And so WWE, no doubt, will have one of those. They may also be hiring one of those for Laurinaitis and or McMahon. So what's going to happen here? My understanding, and I can't recall the lawyer's name, but Laurinaitis' lawyer, I think, was maybe just like some type of a hometown family law lawyer. No offense to anybody that does that type of law, but it would be like Laurinaitis hiring me to come out and give PR type statements and that kind of thing. The best thing to say when the Janal Grant lawsuit dropped, the best thing to have said would have been no comment at the time, but that's not what Laurinaitis' lawyer did. He said my client was as much a victim and released this statement. The question is going to be, will Laurinaitis back off that? If I were in one of those big white shoe New York, Chicago, LA law firms, and I was tasked with representing John Laurinaitis, all of a sudden I'd say, look, first thing that we do is distance ourselves from that comment that your lawyer made. Even if you've got to throw him under the bus, back it over him a time or two, we are going to distance ourselves from that. And when you give your deposition in this case, and Janal Grant's lawyers ask you, well, why did you say that you were a victim too? Well, my lawyer was just incompetent, or he misunderstood me, or something, but that was not my intent.
A courtroom burial, if you will.
Yes, a courtroom burial of his own lawyer who issued the statement, because otherwise he's crossways with WWE and Vince McMahon at that point, because that plays right into Janelle Grant's hand of, there was such a power imbalance between McMahon and Janelle Grant. And, if he called for a threesome, or he called for her to sleep with Laurinaitis, or he called for her to do whatever with some WWE unnamed superstar, that there was such a power imbalance that Grant felt compelled to do that. The other side of that, and the way that she was portrayed, is maybe she was just a freak and liked it and whatever else. So the way that Laurinaitis defends himself and the way his lawyers defend him is really going to be important to how this case gets shaped.
Now, this may be an obvious answer, but does it help Vince's case having John Laurinaitis back on his side?
I believe it does, because, and again, remember, it's not just Vince. This is WWE as well. And the part of the case that would worry me most, if I were defending it, would be WWE's corporate exposure, because strip everything out of it. Strip all of the craziness from the world of wrestling out of it. In ABC Corporation, if you have the president of the company and the head of talent relations sleeping with a legal assistant, I mean, it's just a good that would be a great garden variety sexual harassment, hostile workplace type claim. I mean, it just would. If you just stripped everything else out of it, it would still be a good claim. And then that's where the 40 years of Vince McMahon being Vince McMahon gets relevant all of a sudden. It's, what did WWE know, and when did it know it? When did WWE know it? And so if I'm Janelle Grant's lawyers, I'm focused on the corporation, and I'm not trying to show Vince McMahon as the heel owner, as this bad guy, as Mr. Not as a cartoon character. I'm just trying to show WWE as this publicly traded, multinational, multi-billion-dollar corporation, where they just happen to have a sexual predator at the top of it, and a guy who went along with it or did whatever he did as the head of talent relations, also engaging in sexual relations with this employee. So I try to keep it, if I'm Janelle Grant's lawyer, I'm trying to keep it more in just the average, everyday employment context.
So this arbitration thing that Vince is trying to get, clear this up for me. Vince is willing to do arbitration. Let's give you some money. Let's move on. And Janelle Grant wants a jury. Is that what we're looking at?
Yes, essentially. And the arbitration doesn't necessarily result in automatic money. It is a process that's an alternative. It's called alternative dispute resolution. It's binding arbitration. There's two organizations primarily in America that handle those. And so it's an abbreviated discovery process. The rules of evidence are a little bit relaxed. The rules for discovery are a little bit relaxed, but it's a different arena altogether from litigation. And the case is ultimately decided not by a judge and a jury, but ultimately either one arbitrator or a panel of three. So that's where McMahon wants to be. Arbitrators are typically thought to be more pro-business, and they typically come from defense firms, so they have that mindset instead of a plaintiff's lawyer's mindset like I have. So that's why so many defendants prefer the arbitration, and that's where McMahon wants to be. I think that Janelle Grant's lawyers think it's a whole lot more advantageous to her for the jury to hear all of these salacious details, including 40 years of corporate knowledge on the part of World Wrestling Entertainment.
How much of a hard-on would it give you to let you know you would have 7.5 hours with Vince McMahon under oath?
That would be, I mean, fantastic. So much so that I would ask the judge for permission to extend that. I would ask that McMahon's deposition be 15 hours, twice the normal limit, and occur over 2 days.
I bet you would.
I
So
would I would ask the judge to extend the limit on the number of hours that I could depose McMahon.
So the fact that Vince McMahon has paid her in the past, and we don't really know this gray area of who broke what agreement. If you were her lawyers, and he's not asking for a dismissal, he's asking for arbitration. Is that like a nonverbal way of saying like, hey, let's get in a room, let's give you some money and let's move on?
Well, those things will never be known. They could announce a confidential settlement of this tomorrow, and the terms of it would never be known. It would be interesting whether they could keep it. Smartest thing that could happen here. Smartest thing that could happen here. And I have been in these situations before where, let's say that Massey, one of its subsidiaries, and a guy named Don Blankenship are your defendants in a case, or a mine foreman or a superintendent or somebody. I have seen cases where the money gets paid a certain way so that some of those defendants don't have to report that. When you're dealing with a publicly traded corporation like World Wrestling Entertainment, if World Wrestling Entertainment or its insurance carrier paid, that would have to go on the 10Q and the 10K. But if they funneled all of this money through McMahon, for instance, or through Laurinaitis even, then as private individuals, they would not necessarily have to disclose that. I think that's the smartest thing that could happen here. If I'm the lawyer for the insurance company representing WWE, McMahon, and Laurinaitis, then I'm saying, hey, look, the insurance company is going to pay, and we're going to pay this through McMahon, and it's going to be a confidential, ironclad. WWE would actually be dismissed. So on the books, what's told to shareholders is World Wrestling Entertainment was dismissed as a defendant from the Janal Grant suit, having paid nothing. And except maybe like a deductible, to either pay the lawyers or to, pay towards, if they got some big $100 million, billion-dollar insurance policy or something along those lines, I guarantee you they've probably got the equivalent of like a $10 million deductible or something, which means WWE has to pay the first $10 million of either whatever is paid to her or whatever's paid to the lawyer. So it's very complex. I deal with it every day with pharmaceutical companies and things like that. But your average everyday person, on your auto policy, if you have a deductible and you're in a wreck or something like that, you may have $1,000 deductible on your claim or whatever. It's just exactly like that.
I want to double back and then do a little one or two more questions and get you out of here, because these evil corporations aren't going to sue themselves.
That's exactly.
The organizations that you mentioned that do these arbitrations, you said there were like two big ones. Now, those are private companies that have the ability to have the backing of the law to undergird their decisions. And if so, as someone who loves the privatization of most things, is that a privatization of our judicial system?
It is. And going back, arbitration originally was intended to be a quick, sort of easy alternative to what could be long, drawn out, messy, expensive lawsuit processes. I have my own personal hatred of arbitrations because you know me and I love the Seventh Amendment of the United States Constitution. And anything that runs adverse to that just makes my blood boil. So arbitration started being upheld by the United States Supreme Court, federal appeals courts, federal courts, and Congress passed the Federal Arbitration Act. And so arbitration has the blessing of Congress and the Supreme Court, and they have been in fashion for a long time now. But yes, JAMS and AAA all have both have really good track records of qualified arbitrators who are usually retired judges, retired lawyers. They go through specific training on dispute resolution, and so they have a pretty healthy screening process. They have to make sure that your bona fides are in line if they're going to put you on a panel, or say that your experience level, your expertise is in this type of law, for you to preside as an arbitrator or on the panel of arbitrators that would hear a case like this one.
So to do something like that, to look to the private sector, which of course does everything better than the government. Steve wants to fight with me right now. Trust me. No. Was it sold as an idea of we can ease the burden of the courts if we can just get a lot of stuff out of the,
and the rules are relaxed. You don't have a judge presiding over everything, and you don't, parties have to work a lot of stuff out privately. They just do, because it's not like you can call up to the judge's secretary down at the courthouse and say, hey, I need a hearing. I'm not getting along with the other side. We've got, I need to file a motion on this discovery issue. And okay, well, the judge can see you in 2 months then. Okay. So it forces the parties to try to work through those issues a lot more. And also, it ain't free. You've got to pay the arbitrator or panel of arbitrators as it's going. And that's why plaintiffs, like the people I represent, despise arbitration, because part of the reason that they're coming to a contingency fee personal injury lawyer like myself is because they don't have the bread to sue a large multinational publicly traded corporation. They need some idiot like myself who can take on one of those corporations and say, hey, I think you have such a great case and I believe in your cause so much that I'm going to front the money on experts and filing fees and depositions and all of that, because I believe your case is so winnable that we're going to sue this corporation, and I don't even have to be paid as we're going. I'll get paid a percentage of what I believe that I can win for you or settle for you. So that's the other thing, is big corporations know, hey, we can hold up our end of the arbitration log. If you need to pay each arbitrator a $25,000 retainer fee, and both sides pay that, that guarantees X number of hours of that arbitrator's work.
Now, do you find it unsettling that it seems like arbitration is becoming more the way that you fix these problems? Because the other day I bought a microwave, and when I got the microwave out of the box to go install it, it had a sticker on it, and it said, by installing this microwave, you forego the right to sue for, whatever would happen with a microwave that would give you damages, and you will go straight to arbitration. Do you find that unsettling? Do you not like how that's like where we're going?
I despise arbitration.
Okay.
I mean, because if the microwave is defective and catches fire and burns down the house, why should I have to come up with 25 grand to arbitrate that claim because I bought a freaking defective microwave at Lowe's? I want to sue the microwave manufacturer. I want to sue Lowe's. I want to sue the installer. I want to sue everybody in the chain who's responsible for burning my house to the ground. I don't want to have to go through arbitration and come up with 25 or 50 grand for the privilege of doing so.
Could you see that sticker showing up at SCOTUS one day?
Oh, yeah. I mean, look, it's well settled law at the Supreme Court, and one of the big ones within the last 20 years was arbitration clauses in cell phone contracts. Everybody was like, what? I can't sue AT&T. I have to arbitrate with AT&T. they're screwing me, and this Apple product is crap, and da 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 da. Well, yeah, you're going to arbitrate, and they're going to strip out your rights to belong to a class action. That's usually the other provision that goes hand in hand with an arbitration. You agree to arbitrate and not litigate, and you cannot belong to a class action on that claim.
So one more, this may be a little less germane to what we're talking about. And I ask you this because you have one, I guess, famous or infamous case in our home state where you used the media quite deftly to get you where you needed to go. Now, when the Vince McMahon story hit, it's what everybody was talking about. And then Triple H, like a boss, came in and Dwayne washed the WWE. And Vince McMahon went from page 1 to about page 6. And you can actually watch the popularity of our videos on the subject, because this is now the 4th one, where people are forgetting about this case except for us hardcore IWC nerds. Is it better for Vince McMahon that the popularity of this story is going away moving forward?
Absolutely. I mean, and that's part of the reason why I think Grant's lawyers so badly want this in litigation.
Get it back in the newspapers.
Yes, to get it back in the newspapers, because once it goes to arbitration, it's going to be cloaked in secrecy and confidentiality.
And that means no more content for channels like us.
Right.
And we can't have that.
No. So, yeah, I definitely, with the confidentiality and the secrecy of arbitration, you're not going to hear about things as they develop. If this case is in federal court, every time something happens, you can get on this system called Pacer, and you can say, "Oh, wow, notice of deposition of Vincent Kennedy McMahon Jr. on June the 20th." Okay, wow, on June the 20th, Vinnie Mac's getting his deposition taken by the plaintiff's lawyer. And so, that that's going to happen. You can see the various motions that get filed and all of that. You could follow right along on Pacer with everything that's happening. If this is arbitrated, there's no way that happens.
And if you're an old head, you'll remember that the last WrestleMania of wrestling lawsuits was Vince McMahon and the steroid trial. And he risks outdrawing that ordeal with this.
Right.
One more thing.
When the government's prosecuting you, that can't be arbitrated. That's going to happen in a public forum. As a friend of Vince McMahon's was finding out this week, there's going to be lots of things in the public forum. So, but if you're arbitrating, it doesn't have to be.
I'll wrap it up with this. It's just so strange that now Vince McMahon's only connection with the WWE is when their lawyers are working in concert to get themselves out of a horrendous situation. It didn't have to be like this.
Right. It didn't have to be like this. And it may have been a situation, though, where I think if I had been McMahon, if the girl wanted the $3 million up front, I'd have given it to her. And even if she and her friends, it kind of defeats the purpose. But even if she and her friends went to the Wall Street Journal and said, "Hey, McMahon paid the illegal paralegal $3 million because he sexually harassed her," I don't know that I'd have sued her over that. But of course, that wasn't good enough for her. She's the one who brought this suit, alleging he didn't pay me the rest of my payments. Maybe if he'd have given her the $3, maybe if he'd have not said anything, even if her friend going to the Wall Street Journal, what have you, was the breach of the agreement, maybe we wouldn't be here right now. So who knows? We are.
Yes, we are. If you were a spectator, and you are in your box seats watching this gameplay, and let's just say we're going into halftime, in your opinion, which team is up?
Oh, we aren't at halftime.
Oh,
We
really?
we we are at the start of the first quarter.
Okay, so it doesn't really matter who's up right
And
now.
right now, we don't know whether we're playing the ball game in a climate controlled domed stadium, or if we are out in the middle of nowhere in an open field, snowy stadium that nobody is at the game and going to watch.
Ah, oh man, we're in what seems to be another golden age of wrestling. We both were at WrestleMania 40, and I think I could speak for both of us that for me, it might be the greatest moment of many decades between both of us.
Oh yeah.
And it just is such a bummer. And it's the reason why I've been gone from these wrestling law videos that we're talking about such salacious, unseemly details. And we just can't be talking about how Cody Rhodes and AJ Styles just tore all of France down at the last pay-per-view. And yes, I'm always going to call it pay-per-view. Steve New, thank you all. Thank you for giving us your time. And all of you out there, if you liked all of that, we have a full Stephen P. New playlist. We talk about how he negotiated the Yeet trademark. That's a whole story in of itself. We have one where we talk about where his most famous client, CM Punk, got to become his most famous client. Also, we have a whole bunch of other like reviews, and we have kayfabe collectibles with all the other fellows. Please check all that out. Please give us a like, a comment, and share. Tell your friends about it, and acknowledge the trial chief, Stephen P. New.